Good afternoon and welcome back to the afternoon's events of this wonderful conference. My name is Angela Zito and I am an associate professor here at NYU in anthropology and religious studies. I am the director of the program in religious studies and the co-founder of the Center for Religion and Media, and we have a very long history of cooperation with Ireland House. They welcomed us to run our working groups there from 2003 to 2006, I think it must have been, and that was such a pleasure. So thank you so much to Marion and to Jolie and to Miriam and to the many other people, I think, who made this event possible today. I have one anecdote I would like to share from listening this morning. Years ago, I took a tenure-track position at a small college in Massachusetts that was founded in 1793 and shall remain nameless. There was a lot of buzz on the campus because apparently I was the first woman to ever be given a tenure-track position in the religious studies department. I thought, okay, I get there, I start doing some research. It turns out that that wasn't actually, to me, even the most interesting thing. The most interesting thing was that I was the first Catholic to ever be brought in on the tenure track in that religious studies program. And the year before me, they had hired their first Jew. And the year after me, they hired an African-American woman who was lesbian. So this tells me a couple of different things. She was Protestant. But that religious studies, really, apropos of what Professor Nelson was saying this morning, has been inflected by Protestant thinking for a very long time in the United States. And that, identity claims based on, race, gender, sexual orientation, and religion are very closely imbricated in the United States. So when the door opened, it opened to everybody. So that's all I wanted to say before I introduce our really, really wonderful panelists today. I'm going to do what was done this morning. Professor Stephen Green, who is Fred H. Paulus Professor of Law, Director of the Center for Religion, Law, and Democracy at Willamette University, served for 10 years as Legal Director and Special Counsel for Americans United for Separation of Church and State. He has litigation and appellate experience on First Amendment law, and his most recent book, published last year, is The Bible, the School, and the Constitution, The Clash That Shaped Modern Church-State Doctrine. Leslie C. Griffin is William S. Boyd Professor of Law at the University of Nevada, Las Vegas. She holds a PhD in Religious Studies from Yale and a JD from Stanford, and so I think combines the perfect expertise for today. She authored the casebook Law and Religion, Cases and Materials, and is editor of Law and Religion, Cases in Context. To her left is Mary J. Hickman, who is Professorial Research Fellow at the Center for Irish Studies, St. Mary's University College London, and Professor Emeritus of Sociology, the London Metropolitan University, where she established the Archive of the Irish in Britain. Her work has centered upon the relationship between class, religion, and ethnic identity in tracing the complexity of the incorporation of the Irish in Britain. A most pertinent recent project that Professor Hickman has been involved with closely has centered upon suspect communities, comparing the experiences of the Irish and of Muslims in Britain. To Professor Hickman's left is Khalid Latif, the university chaplain and executive director at the Islamic Center here at NYU. Imam Latif has led, since 2007, this center, the first of its kind ever established at an institution of higher learning in the United States. In 2007, at 24, he also became the youngest chaplain in the history of the New York Police Department, and he is also a founding member of the brand new Of Many Institute for Multi-Faith Leadership at NYU. And finally, we have Patrick J. Ryan, who is Lawrence J. McGinley Professor of Religion and Society at Fordham. Professor Ryan has a degree in comparative religion from Harvard, specializing in Arabic and Islamic studies. For half of his life as a Jesuit, he worked in West Africa, serving as both faculty and administratively at the University of Ghana, Hekima College in Kenya, and as the first president of Loyola Jesuit College in Nigeria's capital of Abuja. Professor Ryan brings his cross and intercultural, scholarly eye, and personal experiences to our panel today. And with that, I would like to turn this over.
Well, good afternoon. I want to thank the directors and staff of the Ireland House for inviting me. I must say that when I got the invitation, I was somewhat surprised and pleased. Not surprised necessarily that why would you invite me, that type of thing, but I'm a historian of the 19th century church and state and was actually familiar with the Phillips case. And actually thought I was probably one of only 5 people in the nation who were familiar with the Phillips case. And so I get this letter in the mail that says, will you come out and we'll do a symposium on it? And I thought, my gosh, I mean, there are other people out there like me, I guess. But also that there would be enough interest in this case, because I've actually for a long time thought it was a rather significant case. So I'm very pleased to participate in this panel. We're supposed to talk about the 20th century, more or less, and the kind of the legacy, the implications of this. I want to think I have enough time to start out actually talking more about the legal as opposed to the constitutional. And the way I want to do that is actually through a couple of anecdotes. And I hope you'll bear with me, but they actually do have some relevance, and to a certain extent they're both somewhat personal. The first is, early on in my legal career, a long time ago, I was a magistrate judge in Alaska through the Alaska court system. And in addition to handling all the kind of rudimentary traffic court, small claims, I was also a misdemeanor court judge. I served as a superior court master, and so I would hear motions many times, both in criminal matters and then also in domestic matters, to refer back to the superior court judge. And I was already thinking of going on to graduate school, which I did shortly thereafter to get my PhD. But it just kind of serendipitously, there was a case that was before me. And it dealt with, unfortunately, too common, sad case of a father who had been sexually abusing his daughter for several years. And he continued to do this, and he went and sought some solace from his pastor, but then continued after receiving his counseling from the pastor. He was a member of a very small, non-denominational, kind of charismatic fundamentalist church. And the pastor was not ordained, had no seminary training or anything at all. And in fact, it's kind of like a group pastorate with his wife. I mean, it was a very kind of informal church, informal type thing. And in the process of this ongoing kind of discussions with the perpetrator, this is prior to his arrest, of course, the pastor decided he would bring in other members of the church. And so they basically brought in, I think, as many as 10 to 12 other parishioners, they don't call them parishioners in this faith, of course, to kind of do group counseling with this father to try to convince him that he was sinful, he should stop abusing his daughter. Even though, like I said, they weren't very successful about it, he continued on. Well, the relevance is, of course, is that the district attorney, after he was arrested, found out about these group counseling sessions. And it fell upon me to make a determination at a hearing of whether the peace penitent privilege would apply not only to the pastor, who was a non-ordained, non-trained, he had a job on the side, it wasn't even a full-time job, but not just that, also to the other members of the congregation who were all counseling. Their claim, or at least the defense counsel's claim, was that within this faith, this non-denominational charismatic faith, everyone was a minister, priesthood of the believers, which actually is related to my denominational background of Baptist. And so asserting a theological claim that basically, and you can see it if those of you who are lawyers, was going to block out everybody who he'd basically taught to, admitted to his sexual abuse to. And the claim was that all of these people should be privileged in this communication. I really had very little problem finding, well, I thought about it, but finding that the pastor who held himself out, and he was recognized as the pastor, was entitled to this privilege, even though it was more of a counseling, not a confessional situation. But I ruled that the parishioners were not privileged, notwithstanding their theological claim. And that was upheld by the Court of Appeals, that you would just, for policy reasons as much as anything, that this would just block out so many people who are potentially important witnesses in the case. But then also just kind of the vagaries of the informality of bringing in whomever you wanted to at particular times, and it wasn't always the same number of people in all these counseling sessions. I just felt it was not appropriate. That actually sparked my interest, and I was already interested in church and state, and so actually the first article I wrote, which I don't think ever got published, was on the peace, penitent, privilege. And that's when I first, in doing that research, came across the Phillips case. And so there's kind of this nice serendipitous aspect to that. The second, actually more personal anecdote, is that several years later, after I was out of graduate school, I guess it was, I just struck up a conversation with my father, who was not at that point, but he was a minister, Protestant minister, and just kind of mentioned this interest in this, just trying to find some commonality with my father to talk about. And he then just kind of described a situation he had been involved with. Very interesting. That in his first parish, his first church, when he was just out of seminary, he had actually had a young woman come to him. And she had, this is early 1950s, and this is in deep southeast Texas, piney woods, the old South kind of place. And this woman, I think was unmarried, she came to him because she was troubled because she had had an abortion, which of course was illegal at that particular point in time. And she had, kind of like the scene from In the Heat of the Night, had gone across the tracks, literally and figuratively, to this African-American woman who was kind of rumored to be an abortionist and had had an abortion with her. A rather rabid district attorney got wind of this, and so he questioned my father, and my father refused to talk because my father knew who the abortionist was and everything like this. So he called my father before the grand jury, and again my father declined. He asserted the privilege in this particular case and stuck to his guns, and the district attorney wanted to hold him in contempt. And according to my father's telling the story, as the judge kind of leaned over and said, no, you're not going to hold a local minister in contempt of court. This just won't work. And I have to say, I had never thought that highly of my father before, but I thought, my gosh, he had some real guts back then to kind of do this type of thing. I guess the reason I tell these, not to just tell personal stories, is that it actually does show, just on the legal aspect, not on the constitutional aspect, the importance of the Phillips case, and it really was the first instance that asserted this and recognized this privilege. It wasn't continually recognized, but it expanded it to beyond a confessional situation within the Catholic Church, which is one of the tenets, into more generally protecting clergy of all faiths to engage in this type of counseling with their parishioners, and so it's an important principle. So that's the legal side. Constitutional side, let me just make 3 points, and I hope I don't steal much of Leslie's thunder, because we may say some similar things. The 3 points I guess I'd like to make just about kind of the more constitutional aspect of this case, and why I think it's important. First, as much as anything, it set the stage for the subplot for church-state developments for 150 years. Protestant-Catholic tension underlay much of church-state development throughout our history. With its corresponding claim of America being a Christian, read Protestant nation from that. Most of the leading cases that arose in church state, many of them, surrounded a Protestant-Catholic conflict, such as exercises in public schools and the public funding of religious institutions. And to a certain extent, this conception of church state as falling within a form of competition really colored the way that church state was looked at for so many years throughout our nation's history. And that even persisted into the 20th century. And it was evident in the concurring opinions in 1947 and 1948 of Everson versus Board of Education, the first case dealing with funding, and the McCollum versus Board of Education, the first case dealing with religious exercises in the public schools. Justice Jackson, in his dissenting opinion in the Everson case, having just returned recently from Nuremberg, he raises this specter of, again, kind of Catholic-Protestant conflict. And he says, the schools in this particular instance, which were Catholic schools that were receiving, they weren't receiving, but the parents were receiving reimbursement for bus fares. He said, these are under the superintendence of a priest and a requirement that religion is always taught as part of the curriculum. And he says, and this is a place where religious and moral training occupy the first place. And then he made this kind of infamous statement that many people have paid attention to. He says, are public schools, if not a product of Protestantism, he's saying this affirmatively, a product of Protestantism, is at least more consistent with it than with the Catholic culture and their scheme of values. And so, coloring even the first modern Supreme Court cases, there was still this kind of sense of, if you talked about church-state, you were talking about competition. And in McCollum versus Board of Education, Justice Frankfurter, in his concurring opinion, he also made some disparaging allusions about the sectarian education and of the importance of assimilation into the values taught and represented by a secular public education system. Obviously, something being telegraphed there. And so this paradigm of a Catholic-Protestant conflict actually dominated church-state funding controversies probably up and through the 1970s. And groups such as the former group I worked for, at the time called Protestants and Other Americans United for Separation of Church and State, perpetuated this paradigm with their opposition to religious funding, always calling it procreate. And so actually I think this prospective Catholic-Protestant conflict, it even entered, as we all know, the 1960 election, where John F. Kennedy had to appear for a group of Southern Protestant ministers to assert his bona fides about separation of church and state. And so that's not the best history, but it's still a legacy. And so I think we need to at least recognize that Phillips kind of set that perennial question. And you can see it in the arguments of the prosecutor in this case, about whether there can actually be a religious norm in America, such that all other faith systems and practices that deviate from that are legitimate only to the extent to which they assimilate into the larger culture. And I think that's one of the important statements that we see in the Phillips case that comes out of course, the arguments of the defense, and then in DeWitt Clinton's opinion. The second point of legacy that I think is evident in the Phillips is, of course, it was one of the first cases, if not the first case, to explore the boundaries of the Free Exercise Clause. The issue of what is necessary to receive a free exercise protection was brought up in this case. Whether a neutral law, such as a requirement that you must testify on the admission of a suspected wrongdoer, should prevail over the burdens of religion caused by compliance with that neutral law. And here, of course, Clinton basically says yes, that you need to create exceptions to the law. Phillips basically was a precursor to the Sherbert versus Verner case, actually 150 years later in 1963. And that debate still continues on today because, of course, the Supreme Court in the Employment Division versus Smith case in 1990 went back on that and basically said neutral laws of general applicability do not have to grant religious exceptions. But Phillips, of course, was the first case, really, that came out with that principle. The third point, and my last point, is that Phillips is significant and the legacy still remains today because it affirmed a central tenet of both religious liberty and non-establishment, that of equal standing of all faiths with respect to their political and civil rights. That basically we do not have second-class citizens account of their religious faith. This marks the 30th anniversary of Justice O'Connor's endorsement test, and both Leslie and I are going to be going to a conference in a couple of days about this. I would say her greatest contribution was to remind us of a strain in church-state thought that no person should suffer civilly or be considered a second-class citizen because of their religious beliefs. Once again, you see this in the arguments in the Phillips case. O'Connor wrote that religious insiders and outsiders, basically wrote of religious insiders and outsiders, that the endorsement of religion sends a message to non-observants that they are in fact outsiders, not full participants, and basically not subject to full legal protection, in essence. Now, this strain actually goes back to Madison's Memorial and Remonstrance, James Madison's Memorial and Remonstrance, where he wrote about the value of what he called equal conditions. So in essence, beyond saying that there is an important right about religious liberty and free religious expression, Madison goes on and says, but even beyond that, we need to have within our nation equal conditions, that all faiths are considered equal with respect to their civil rights. In this vein, I mean their abilities, their legal rights. Now, as mentioned in the morning panel, this did fly in the face of reality in America. All states at the time of the founding, subsequent to it, the early part of the 19th century, maintained religious prerequisites for office holding, albeit they were more progressive than they were in the colonial period. As significant, all states imposed religious requirements for oath-taking, usually a belief in God, sometimes Jesus, that there must be, in fact, a belief in rewards and punishments after death. This was actually one of the most effective forms of a religious civil disability. Basically, to hold public office, as was mentioned, to testify, to be a juror, to be able to swear out many important legal documents. All of these required an oath. And if you are unable to take an oath to swear to the belief in God and rewards and judgments after death, then you were disqualified. This oath requirement persisted until the late 19th century and excluded Jews, Unitarians, Universalists, freethinkers, and other nonconformists. And in fact, someone made reference to the burning of the Ursuline convent in 1834. An interesting sidebar to that is about a year later, there was in fact a trial about some of the Protestants who were charged with doing this, and they objected to the testimony of some of the nuns. And the ground they objected to it was because they could go into the confession and receive penance for lying in court, then we could not trust them to testify honestly in court. Fortunately, the judge declined that motion to exclude their testimony. So, back to Phillips. In Phillips, both Riker and Clinton both recognized this connection between equal conditions and religious liberty and disestablishment. Riker said that the Constitution required not only toleration, not just liberty, but also equality. He says, we all stand equal in the eyes of the law. And Clinton picked up on this in his opinion. He expressly equated legal disabilities with a religious establishment. Remarkable. Calling them, quote, repugnant to the first principles of civil and political liberty. Now, I doubt that Justice O'Connor ever read or ever heard of the Phillips case. Maybe she has. I can ask her this in a couple of days. But I think Phillips clearly planted that third impulse in American jurisprudence, and as a result, the law owes much to the Phillips case. Thank you.